part 3 of the video, that is LLP. So already in part 2 we have covered till advantages of LLP form. Now we look into part 3, which is about incorporation of LLP. Now incorporation, when it comes to incorporation, the first thing that the LLP has to do is that they will have to submit the form in the prescribed manner. So two or more persons, just a minute. So two or more persons who are carrying on the business of LLP, they will have to subscribe their names to incorporation document. Why is the requirement of two persons? Because they will have to be at least two persons to form an LLP, and then the incorporation document will have to be filed in such a manner, that is prescribed manner, along with the fees, with the registrar of the state in which a registered office of the LLP is situated. Let's take for example, if this LLP is going to be situated in Kerala, then Register of Kerala. If it's going to be situated, let's take for example in Karnataka, then in that case we will have to submit the incorporation document in the prescribed manner. Along with that, we have to pay the fees and we have to submit this to the Registrar of State. A statement to be filed, that statement will have to be in the prescribed form, and so we will have to file the incorporation document, and apart from that we also have to submit a statement. Now this statement has to be given by advocate, a company secretary, a chartered accountant, a cost accountant who is engaged in the formation of LLP, and also by anyone who has subscribed his name to the incorporation document, that is basically the partner of LLP, and all the requirements of the act and rules will have to be complied with. So number one thing that we will have to do is we have to submit the form in prescribed manner, and then along with that we also have to submit a statement. A statement which is to be given by CA or CS or CMA or advocate who is engaged in formation of LLP, and we have to comply with all the rules. So form plus statement plus fees. We have to submit the form in prescribed manner, plus we have to pay the fees. This forms for the incorporation plus fees, plus we also have to submit the statement which is to be given by CA or CS or CMA or advocate, plus one subscriber to the memorandum, that is basically the partner. And this incorporation document will have to be in the prescribed form. So what all this document will contain? I mean, the form that we are submitting to the Registrar of State. So it will contain basic details like name, LLP's business, and where the registered office of the LLP is situated, and name and address of the persons who are partners of LLP on incorporation. So the persons who are going to be the partners of LLP, name and address of the persons who are designated partners, and other information regarding the proposed LLP. So these information will be contained therein. And now if at all any person makes a statement that is false, or the one that he does not believe it to be true, that is basically, we'll have to submit the form, and then we also have to submit the statement, plus we have to pay the fees. Now that form will contain all the details like LLP's name, LLP's registered address, registered office address, and LLP's partners details, LLP's designated partner details, and other information as may be required. Now if at all any person is furnishing false information, or a person knows that the information is not true and still furnishes that information, in that case he will be punishable with imprisonment, which may extend to 2 years maximum, and fine, which will not be less than 10,000 but which may extend to 5 lakh. So imprisonment up to 2 years plus fine 10,000 to 5 lakh. So incorporation by registration. So once we submit the form, the statement, that is the ones that we saw over here, is that we will have to submit the form, and then we have to pay the fees, plus we also have to submit the statement. So once all of this is done, and then registrar will verify this information, and within a period of 14 days of us submitting the information, we will register the incorporation document and will give a certificate of incorporation of LLP. So that certificate of incorporation of LLP will contain details such as LLP's name, LLP's registered office, and then ROC's sign, jurisdiction, etc. Now once he has given the certificate of incorporation, he may accept that statement is delivered and sufficient information that the requirement has been complied with. Now the certificate that has been issued will be signed by registrar and will be authenticated by his official seal. So in the bottom of the document, that is certificate of incorporation, we can find the registrar's signature as well as seal, official seal. Now once certificate has been given, that is a conclusive evidence that LLP is being incorporated by the name specified therein. A registered office of LLP and seen therein. So registered office. Now generally the information that is given in the incorporation form, wherein we have to give all the details including the registered office address. So that address will be the address to which all the information, communication and notices will be received. Document will be served on LLP or partner or designated partner on that registered office address only. So if at all there's any change in the place of registered office, then in that case the LLP has to file notice of change with the registrar in such form and manner, in the prescribed form and manner, and only upon filing that statement that change will have effect. If at all LLP is contravening provisions, basically registered office address is of extreme importance because all the communication notices will be received at the registered office only. If at all any communication or notice is to be received by partner or maybe designated partner or by the LLP, it will be addressed to the registered office only. So if at all there is any change in the registered office, then the same will have to be filed with the registrar. Unless and until it's filed with the registrar, the change will not take place. So basically it will not have effect. So if at all LLP is contravening any of these provisions, and in that case penalty is 500 for each day plus subject to maximum of 50,000. So let's say for example this particular contravention is continuing for a period of 200 days. Now in that case the penalty will be 500 to 200, which is 1 lakh. But here the maximum limit is 50,000. So therefore it will be 50,000. Let's take for example this contravention continues for 10 days, and in that case it will be 500 into 10, which is 5,000. Which is well within the limit of this 50,000, so 5,000 will be imposed. The effect of registration. Once this LLP is registered, it will get the legal character. Just like a company, it will become a separate legal entity, wherein partners will be different and LLP will be different. Once LLP is registered, it is capable of suing and being sued. That is, it can sue other persons and it's capable of being sued by any other third party. It can acquire, hold and develop or dispose of any property, mobile or immovable property, tangible or intangible property, just like any other individual. And it has common seal if it decides to have one. Again, it's not mandatory to have a common seal, as we already saw. Common seal is nothing but official signature of LLP. If it does not choose to have a common seal, now in that case the document can be authenticated by 2 designated partners if at all it does not have common seal. And also it can do and suffer other acts as body corporate may lawfully do and suffer. Next is about the name. So as far as name is concerned, the limited liability partnership should have the following acronyms. One is, it should have this acronym LLP as the last word of name, or it can have limited liability partnership as last words of name. Let's take for example, there's an LLP incorporated by name ABC. In that case, it should choose to have its name either as ABC LLP or as ABC Limited Liability Partnership. So generally that name should not be undesirable or should not be identical or should not resemble to that of any other LLP or company or registered trademark. Let's take for example this one LLP JC LLP. Now if at all this another LLP which is JC, again the words are different but it's identical or it resembles to that of the other LLP. So such a name will not be allowed. In the opinion of central government, if at all the name is undesirable or if it's resembling, then in that case this name will not be allowed. Reservation of name. Now reservation of name, a person will have to apply in the prescribed form and manner to the registrar for reservation of name. So they will have to state the name of the proposed LLP or the name to which LLP proposes to change its name. So when it's for the first time, they will have to specify in the form the name that they are willing to give for the proposed LLP, or if at all they are going to change their old name and new name. So once the application is received by the registrar, it may be either rejected or it may be approved. So once it is approved, then in that case it will be reserved for a period of 3 months from the date of intimation within which the LLP or the company LLP will have to confirm. Change of name of LLP. So if at all there is any change in the name of LLP, let's take for example if the LLP's name is identical or it nearly resembles the name of another LLP. Now in that case, central government will direct them to change the name. In that case, central government will direct the LLP to change its name within a period of 3 months from the date of issue of such direction. So if at all it's identical or it resembles the name of the LLP, now in that case central government will direct the LLP to change that name within a period of 3 months. And within a period of 3 months, LLP will have to change its name. Within 3 months from the date of issue of direction by central government. So if at all any application is made by proprietor of registered trademark, then that application or lawsuit will be maintainable for a period of 3 years from the date of incorporation or registration or change of name of LLP under this act. So from the date of application, it will be valid for a period of 3 years. And if at all LLP changes its name, then within a period of 15 days from the date of change, LLP also have to give notice to ROC registrar, not to ROC, but to the registrar of state, along with the order of central government imposing the LLP to change its name, so instructing the LLP to change its name. And within 30 days of the change in certificate of incorporation, the LLP will have to change its name in the LLP agreement also. So basically, if central government is directing LLP to change its name, it has to change its name within a period of 3 months from the date of issue of such direction by central government. After changing the name, LLP will have to inform or intimate this to ROC, not to ROC, to the registrar within a period of 15 days. And the registrar will carry out these changes in the certificate of incorporation, and within 30 days, the LLP will have to change its name in the LLP agreement as well, once a change is made in the certificate of incorporation. If at all LLP is making any default in complying with the direction, central government will have to allot a new name to LLP. If at all LLP is not changing its name despite instructions from central government, then in that case central government themselves will allot a new name, and then registrar will enter that new name in the register and will issue a fresh certificate of incorporation. Differences with other forms of organization is the last part. So this is actually very simple. Differences when compared with other forms of organization. Regulating Act for LLP, as we know, is LLP Act 2008, whereas for partnership it's Indian Partnership Act 1932. Body corporate. So LLP is a body corporate, whereas as we know, partnership firm is not a body corporate, separate legal entity. So LLP is a separate legal entity just like a company, whereas in case of partnership firm, there is no separate legal entity. That is, partners and firm are one and the same. Creation. LLP is created by registration under LLP Act 2008, whereas partnership firm is created by agreement, not by registration. Registration over here in case of LLP is mandatory. Only then LLP can sue and be sued in its own name, whereas over here registration is voluntary in case of firm. But anyways, only registered partnership can sue third parties. An unregistered partnership can be sued by third parties. But for a partnership firm to sue other parties, it must be registered. Perpetual succession. As we know, LLP is just like a company, it has got separate legal character, corporate character, so it has perpetual succession, which means that the changes in partners will not affect the LLP. So death, insanity or retirement or insolvency of partners will not affect the existence of LLP. Partners may join only, but its existence continues forever. Whereas in case of partnership firm, death, insanity or retirement or insolvency definitely affects the existence of partnership firm because it has no perpetual succession. Name. So name should, in case of LLP, name should contain the suffix LLP or limited liability partnership. Whereas in case of partnership firm, there is no such guideline. They can have any name as per their choice. Liability. So in case of LLP, liability is limited to the extent of agreed contribution, except in case of willful fraud. In case of willful fraud, what happens is that there is no limited liability. If a person is involved in willful fraud, then that person will have to contribute to the liability, and that will be unlimited. Whereas in case of partnership firm, liability is unlimited. All the partners are jointly and severally liable. If at all to meet out the liability, assets of the firm are not sufficient, in that case the liability will be extended even to personal assets of the partners from which they will have to contribute. Mutual agency. So in case of LLP, partner can bind LLP but not other partners, so there is no mutual agency. Whereas in case of partnership firm, there is mutual agency because partners are acting both as agents as well as principal. So partner, if he does an act, others will be bound by that act. Whereas if some other person does an act within the firm, some other partner does any act within the firm, then others will be bound by the same. So common seal. So common seal in case of LLP, it may have common seal as official signature, whereas in case of partnership, there is no such concept. Legal compliance. Over here, designated partners are responsible, whereas in case of partnership firm, only partners are responsible for all the compliances and penalties. And in case of LLP, regarding annual filing of documents, they have to submit or file the annual statement of income, statement of solvency and annual return every year. Whereas in case of partnership firm, there is no such requirement to file any annual document with registrar of firms. Foreign partnership. Even foreign nationals can become partner in LLP, whereas in case of partnership firm, foreign nationals cannot become a partner. Minor as partner. So in case of LLP, even minor can be admitted or minor cannot be admitted. Minor cannot be admitted to benefits of LLP, whereas in case of partnership, a minor cannot be admitted as partner because he is incompetent to contract, but at the same time he can be admitted to the benefits of partnership with the prior consent of existing partners. Next is the difference between LLP and limited liability companies. Regulating Act for LLP is LLP Act 2008, whereas for company it is Companies Act 2013. Members or partners of LLP are known as partners only. For limited liability company, they are known as members. Internal governance structure. Over here it's governed by LLP, it's governed by contract or agreement. In case of limited liability company, it's internal governance structure is regulated by statute, that is Companies Act 2013. Name for LLP, it should have suffix LLP or limited liability partnership. Whereas for company, in case of private company, it should have private limited as suffix, and in case of public limited company, it should have limited as suffix. Number of members or partners. For LLP, they will have to be minimum of 2 members. Maximum, there is no such limit. Whereas in case of company, in case of private company, there has to be at least 2 members, maximum is 200 members, and for a public company, there will have to be a minimum of 7 members, and maximum there is no such limit. Liability of members or partners in case of LLP will be limited only to the extent of agreed contribution, except in case of willful fraud. And for company, it's limited to the extent of amount unpaid on the shares of money. Again, limited company can be 2 types: limited by shares or limited by guarantee. It's limited by shares, then only to the extent of unpaid amount on the share capital, whereas it's limited by guarantee, then to the extent of amount which is guaranteed to be contributed by them. One difference is that in case of company limited by share capital, the members may be agreed to contribute to the capital either at the time of winding up or maybe even at the time of running the company. Whereas in case of company limited by guarantee, they will be asked to contribute only at the time of winding up. Management. So in case of LLP, it will be managed by the designated partners. Whereas in case of company, we managed by the board of directors. So shareholders are owners. But typically in a company, shareholders or owners is many in number. They will not be able to manage a company. So affairs of the company will be managed by board of directors. And in case of LLP, minimum number of directors are designated partners. So for LLP, there has to be minimum 2 partners. And as far as designated partners are concerned, they will have to be at least 2 designated partners. And for a private company, at least 2 directors will have to be there. And for public company, there will have to be at least 3 directors. Thank you.